Shalom. My name is Michael Decker, and I'm a lawyer within the law offices of Cohen, Decker, Pex, and Brosh. Today I wanted to discuss a very important matter with regards to immigration and with regards to the opening of joint life applications between an Israeli spouse and a foreign spouse, and particularly the invitation or the joining of minor children of a foreign spouse from a previous relationship. In a situation of the joining and the invitation of minor children from a previous relationship, the Interior Ministry recently updated the relevant policies on the matter, and today the Interior Ministry will need to check whether the additional parent, the father or the mother that's abroad, give their consent. So basically, the new policy states that the Interior Ministry will send to the foreign parent a request to know whether the foreign parent agrees with the fact that the minor child will obtain citizenship in Israel and reside in Israel or not. If within 6 months the foreign parent does not respond at all, then the Interior Ministry sees this lack of response as an agreement, and then the child can naturalize in Israel together with his parent. If, however, the foreign parent says that they do not agree at all that the minor child even resides in Israel, then the Interior Ministry will notify the parent that's being invited as the spouse of an Israeli to have the minor leave the country when his tourist visa is over to reside with the other parent. If the other parent says that he doesn't mind that the child resides in Israel, but he doesn't want him to naturalize and become a citizen, then the Interior Ministry will only upgrade this minor status to permanent residency eventually and not to citizenship. And when the child becomes of age, after he's an adult, when he's 18, he can naturalize himself. And you can learn more about this in various videos and articles we wrote on our website. There are cases also where the parent that is invited as a foreign spouse of an Israeli, has full custody of the child, and then the approval and the consent of the foreign additional parent is not required. But for this, it is necessary to bring a court order that is original and that has an apostille stamp confirming clearly that the parent has full custody over the child, and at times this court order may even need to be enforced in Israel and ratified in Israel by Israeli courts. In addition, if the minor child is above the age of 15, then the Interior Ministry requires that the minor child lived at least 2 years with the foreign parent prior to the submission of the application. And if this is not the case, then the file will be transferred to the headquarters of the Interior Ministry for further review. If the minor child is above the age of 17 and a half, even then the file will be transferred to the headquarters for further review. In addition, it is important to note that only married couples are able to invite into Israel to join minor children of a foreign spouse, and this is not possible if you're known in public or under common law marriage. So therefore, if there is a couple in Israel that has that wants to open a joint life application and they're not married and the foreign spouse has minor children, they have to get married, which raises other problems, because in Israel you can only get married if you're of the same religion, a Jew to a Jew, a Christian to a Christian, and a Muslim to a Muslim. And therefore, it's not even possible to get married in Israel. However, our office has solutions for this as well. It is possible to get married in Paraguay or El Salvador by proxy without even needing to leave the country for that purpose. And in Paraguay, it's necessary for only one of the partners in the relationship to fly to Paraguay in order to obtain a mutual marriage license. I hope this video was of assistance to you, and if you have any questions, you can feel free to ask us. Thank you very much for your time.